All right. Each side will have 15 minutes to present their arguments. The appellant may reserve up to 5. You just need to let me know, and we're ready to proceed.
Thank you. Marty Delahunty with Slater and Serves on behalf of the appellant, State of Jake Johnson. I would like to reserve 3 minutes.
That'll be fine. Thank you.
The factual situation with respect to this case from below is that this is a medical malpractice nursing claim brought as a result of injuries to and the death of Jake Johnson. It was found below. After it was filed, the appellee filed and moved to enforce an arbitration agreement that had been executed by a representative of Mr. Johnson when he became a resident facility. He didn't, there's no dispute he didn't execute it himself. He had suffered a stroke and was ventilator dependent at the time he was brought in. Subsequent to being brought to the facility, he suffocated to death on his respirator, which brought forth the claim that was presented.
And let me stop you for just a moment because I want to be clear about who it was who signed the arbitration agreement.
It was signed by one of his children.
Okay.
And what was their authority?
I believe it was under a medical power of attorney. Bless you. I believe it was under medical power of attorney that was signed. We didn't dispute, and we don't, it's not worth the aggravation or effort to dispute whether or not an arbitration provision is enforceable with respect to a survivorship claim. There are a lot of hoops that we can jump through and try to argue with capacity, but the Ohio Supreme Court has seemed to have viewed that with respect to the survivorship claims, age, negotiating position, explanations just don't seem to have any weight with respect to that.
Well, but, and I know that's not necessarily in this case, but we do like to understand the underlying legal issues and how we got to the place that we're at. And I guess I'm just not sure how someone, a medical attorney has the right to legally bind somebody. But I mean, if that issue's not before the court.
Well, it's not before the court, and we're fine with it. So we did take the position that, fine, you can enforce the arbitration agreement with respect to the survivorship claim. Because if the individual did have the authority to act on Jake Johnson's behalf, then Jake Johnson himself could have executed a valid arbitration agreement with respect to his claims that would arise during his term. The problem is, though, that his wrongful death claim was also mandated to go to arbitration by the trial court below. We specifically argued that the wrongful death claim was not subject to the arbitration provisions because it's not Jake Johnson's claim. No matter any way you slice it, he had no ability, nor did his legal representative have an ability, to infringe upon the rights of his next of kin and other beneficiaries under Ohio's wrongful death act. The Supreme Court of Ohio already looked at this case not only in Peters versus Columbus Steel, where it stated that the beneficiaries of a wrongful death, a decedent, were not bound by an arbitration agreement executed by that decedent. We've also looked at it in the other aspects of Thompson versus Wayne. Medical malpractice case, an individual has sued a doctor for purposes of malpractice. There is a settlement, a complete release of all claims. The individual died. And then his estate, his beneficiaries, brought a wrongful death claim. The defendant argued, wait a minute, the decedent waived any and all further claims. There is no right to bring any claim against us. The Ohio Supreme Court said no. That individual does not have any right to impinge upon the rights of the others. If I myself would die and I had no beneficiaries, I had no other next of kin, even if I was wrongfully caused to die, there is no claim in Ohio. Because the claim is not the decedent's claim. The claim is the claim only of the next of kin and other beneficiaries under law. Therefore, those are the individuals. The trial court below looked at the case of the U.S. Supreme Court case Marmot and said that Marmot controlled. All that Marmot says is that we cannot have a categorical denial of arbitrations in our state. And we don't. In Ohio, if you get the right people to agree or to sign this contract with you, you can have a valid arbitration agreement with respect to the wrongful death claim. There's no provision that says you can't do it. You just have to have the right people to engage in the contract with. In any type of contract claim, you only have the right to contract with those people who have the rights to give you what you want. I can't engage in a contract where I waive your rights or the rights of your children or other next of kin, because I don't own that right, nor do I own the right to my own wrongful death claim. It's not mine. The state of Ohio does not provide any measure by which an individual is recompensed for his own death. Under the Ohio's wrongful death statute, the only people who receive compensation are those people who at law are determined to have suffered as a result of that loss. And those are the other next of kin, the parents, the children, the brothers and sisters. There is no claim for a decedent. There's no claim in Ohio for the loss of your own life. You can receive pain and suffering, but that's your survivorship claim. Separate and independent. In the appellant's position is the trial court erred. The review for this court is not abuse of discretion. The question is, did the parties who brought this claim agree to arbitration? That's a de novo review. And in this case, the parties themselves did not execute an agreement to arbitrate their claims. Nor can, there's absolutely no evidence below that the parties were even consulted with respect to this. So those individuals did not execute a waiver. They did not agree to keep the matter hidden. This avenue of a wrongful death claim at least provides the family the opportunity to show to the public what took place in this nursing home, as opposed to the arbitration agreement, which keeps everything confidential with no disclosure to the public at all with respect to anything.
If we could go back just for a moment to the issue of whichever one of the children signed on the basis of this medical power of attorney. And again, this may not be an issue before us, but in the court below, did anyone argue that the individual who signed on behalf of the decedent would be deemed as having waived in his capacity as a beneficiary? In other words, he would not then be on equal footing with the other children because he had signed this arbitration.
No, that wasn't argued.
Okay.
And I think that we would run into some complications with how Ohio gathers its claims, in that only the legal representative of the estate can advance the claims, both the survivorship claims and the wrongful death. Even though, as an attorney, I'm representing totally different parties, I'm still marshaling everything under one banner, mostly for judicial economy. No court wants to hear 25 different lawsuits on the exact same set of facts. So no, it wasn't argued before. And Your Honor is bringing up, I am aware of one district court appeals case where the only sole surviving beneficiary under Ohio law was the person who executed the agreement, and the court found that they executed in both parts, both as an individual and as a beneficiary. But in this case, there are, although the facts aren't, nor was it argued on the facts, and there were multiple beneficiaries in this particular case. So with respect to that, what we'd ask the court to do is to affirm in part and reverse in part, because we don't have an argument with respect to the aspect of the court's ruling saying that the survivorship claim is subject to the arbitration agreement. Our argument is that the court erred in finding that the wrongful death claims are subject to the arbitration agreement and would be compelled to be arbitrated. Thank you.
Good afternoon, Your Honors. Or still good morning. My name is Susan Audie, and I'm here on behalf of Canal Point Nursing Home. I would like to frame the issue a little bit differently than Mr. Del Conte has framed it. The issue on this appeal is whether Peters is preempted by the Federal Arbitration Act. And that I do agree that your standard of review is de novo. That's because preemption is a question of law, not a question of fact. And I do also want to make clear that there is no argument about the representative who signed the arbitration agreement and whether that representative had authority. That's been conceded here. It was not addressed below. So whether the personal representative of the decedent had the authority to enter into the agreement is not argued below. It was not addressed below. For all practical purposes for this court, it is not before this court. All that is before this court is whether the Federal Arbitration Act preempts the categorical rule created by the Supreme Court in Peters versus Columbus Steel Casting. And that is a question of law for this court to decide. Remember that the Federal Arbitration Act has a savings clause, and I have outlined the preemption analysis in our brief. But what we're looking at is whether that savings clause, where a rule that would create some type of categorical prohibition against pre-dispute arbitration agreements, if it would be something that would be invalidated by some rule of law or equity, then it would not fall within that category. But that's not argued here. Peters versus Columbus Steel Casting does not create that type of contract or type of rule that would apply to invalidate any contract. It only invalidates the rule as to arbitration agreements. And that's why it is preempted under Marmette. And Marmette, again, expanding the U.S. Supreme Court's ruling in AT&T versus Concepcion, but Marmette dealt specifically with arbitration agreements in nursing homes. And they said right there is nothing in the Federal Arbitration Act that would preempt any type of personal injury or wrongful death claim under the Act. And states cannot create a categorical rule either by statute or by common law, as the Supreme Court did here in Peters, saying that you cannot have an arbitration agreement that cannot be enforced against a wrongful death beneficiary.
And that's their whole argument, though, that it's not categorical, because if the beneficiaries want to go together and arbitrate, they're allowed to, or the personal representative for the beneficiaries.
But what Peters is saying, by invalidating any type of pre-dispute arbitration agreement, by invalidating it, not allowing it to be enforced against any wrongful death beneficiary, they created a categorical rule that is directly contrary to Marmette and the Federal Arbitration Act. The only types of things that could invalidate a contract would be any type of rule that would invalidate an entire contract, like fraud, arrest, unconscionability. And when you look at Marmette, because it sent it back to the West Virginia court to address whether there was any state law grounds to invalidate that arbitration agreement, the only thing they argued was unconscionability, because that's the only argument that they could come up with. What happens with Peters is because they said, well, you're not going to be allowed to use any type of arbitration agreement, that you're not going to be able to enforce it against any wrongful death claim. They created a categorical rule that Marmette and the Supreme Court in AT&T versus Concepcion said you cannot have. Now, I did outline in our brief that there is a 5th District Court case that addressed the same argument. It didn't do the savings clause or the invalidation on unconscionability or duress or fraud. That was the McFadden case. And they did come out and say that there was no preemption. I'm arguing, I would posit to this court here, if there is any concern on your part that Peters creates that type of categorical rule against arbitration agreements for wrongful death claims, that give the Supreme Court, the Ohio Supreme Court, the opportunity to address that in a certified conflict. What the trial court did here is they looked at Marmette, they looked at the preemption principles and says, Peters creates a categorical rule against pre-dispute arbitration agreements. Again, to the extent that you are troubled by that or you're concerned whether that is an issue that should be addressed by our Supreme Court, if this court were to affirm, that would create a conflict or set up a conflict that the Supreme Court could address. But when you look at what Peters has done in this case, it is the exact type of categorical rule against wrongful death, arbitrating wrongful death claims that Marmette said that you cannot have.
But couldn't we apply Peters so that it would not create a categorical denial?
The only way that you would be able to do that is if Peters somehow would be a defense or a way to invalidate wrongful death claims that would apply to all contracts, and it doesn't. What they're saying is that because it's an independent claim, not a derivative claim, that it's not going to be, it cannot be enforced against a wrongful death beneficiary. But that is...
That hasn't consented to it.
That's, pardon me?
That has not consented to it.
That is not consented to, but that's not a defense that would invalidate an entire contract. That is only specific to arbitration agreements. And that's what Peters has done. It's created a categorical rule against pre-dispute arbitration agreements for wrongful death claims. It's only in the wrongful death context. It doesn't go to anything else. It's not invalidating any contract. It's not looking at it on your normal contract offenses like fraud, duress, unconscionability, anything like that. They're just saying, because you didn't sign this, that it's not enforceable because in Ohio we have an independent, not a derivative claim. And our position is that it really doesn't make any difference whether it's an independent or derivative claim, because you will see, and I've cited in our brief, cases that have found Marmette preempts. The Marmette and the Federal Arbitration Act preempts state laws, common law, and statute that have created a categorical rule against our pre-dispute arbitration agreements. You will also find courts on the other side that say there is no preemption. So I'm not going to come up here and say everybody's on my side. They're not. I've cited those that are. There are quite a few that have come out since that time that have also gone both ways. So I'm not saying that this is a well-settled area of law. But to this extent, that Peters does create this pre-dispute or invalidates pre-dispute arbitration agreements for wrongful death claims. It is not a contract offense that applies to all contracts, only to arbitration. And that's what both Marmette and AT&T versus Concepcion say you cannot do. And when you do that, when a state does that, it is preempted by the Federal Arbitration Act. And for those reasons, we would ask the court to affirm this case. And again, as to any concern or consideration that you feel that this may need the attention of the Supreme Court. McFadden was appealed to the House Supreme Court and it was declined on jurisdictional grounds. If this court were to affirm the trial court here, it would create a conflict and it would be able to then be presented up to the Supreme Court upon your certifying an agreement. There would be a conflict.
But we have to, as judges, we have to determine what we think the law is.
I fully understand that.
So we can't just affirm something to get it up on conflict.
No, I'm not saying that. I'm saying it to the extent that you have some concerns or are on the fence whether this does create a categorical rule, then it would give the opportunity for the Supreme Court to address it. Because this is an issue that's being litigated across the country, whether Marmette preempts state laws that categorically deny enforcing arbitration agreements that were executed pre-dispute, and then they cannot be enforced against wrongful death claimants after. This is an issue that's being litigated across the country, so it's not just here in Ohio. But to the extent that we want to give some type of finality so that we can go on in cases from here, it would be nice not to have a lot of differing decisions. We would like to have some type of certainty. But I understand that you have to come to that yourself. But our position is that Peters, by coming out and saying that you cannot have a pre-dispute arbitration agreement that will be enforceable against a wrongful death claim by wrongful death then brought for the benefit of wrongful death beneficiaries. That is a categorical rule similar to that was invalidated in Marmette and is prohibited by AT&T versus Concepcion. And it really makes no difference whether Ohio looks at claims as an independent claim or whether they look at them as derivative claim. And as a point of clarification, Thompson versus Wing was a case that went to judgment on a survivorship claim, and then the subsequent wrongful death claim was brought. There is some language in there about release, but it actually was a case that went to judgment. And that's where the basis of the independent versus derivative claim comes from, and that's what Peters relied on in finding that you couldn't enforce an arbitration agreement against as to a wrongful death claim brought on behalf of wrongful death beneficiaries. And it's our position, as I'm repeating one last time, is that that is a categorical rule that prohibits pre-dispute arbitration agreements for wrongful death claims, and ask that you affirm the trial court. Thank you.
We still have around 5 minutes for me.
Try not to use it all.
It's your time, so.
What I'd like to make clear, and I think we're losing it a little bit here, is what Peters did, the Supreme Court of Peters, what they did, was they affirmed contract law that we've had in Ohio forever. Who owns a claim and who can contract? In Peters, what the Supreme Court said was, this is a contract question. Who signed this contract or was subject to it, and who isn't subject to it? The individual who signed it, the employee, it was a dispute resolution plan, was bound by it with respect to his claims that he owned, that he could ever process. What the court went on to say is he died, he had a wrongful death. Looking at Ohio's law, who now has rights? His beneficiaries had separate and independent causes of action. And all they said is they didn't sign this contract. They didn't negotiate anything. They didn't receive the benefit of anything. They have separate claims, and if they wish to pursue them in court, they can. They aren't bound by this arbitration agreement executed by someone else with respect to their individual rights. The court said the deceased employee could not restrict his beneficiaries to arbitration of their wrongful death claims because he held not the right to those claims. They accrued independently to his beneficiaries for the injuries they personally suffered as a result of his death. All Peters is doing is echoing contract law from Ohio. You can't bind someone to a contract with respect to their individual separate rights unless they sign the contract, unless they bargain for some benefit of the contract for themselves. There's no dispute, if we look at this contractually, that the beneficiaries receive absolutely no benefit. They have no negotiating position in it. They didn't review the terms of the contract. This is a separate and independent. Is this a categorical rule preventing arbitration of wrongful death cases? No. What it is stating that if you want to bind somebody to an agreement, you got to get it to sign it. That's all this is saying. They have separate and independent. And the reason it's separate and independent, rather than derivative, as in some other cases like West Virginia where wrongful death is a derivative claim, is that it creates separate individual claims that can be pursued by those individuals. They have the individual right with respect to their claims, and they have the right to determine how those claims will proceed. And in Peters, the court went on to say that they're not bound by the arbitration agreement, but they could elect to proceed under it if they wish. It leaves it up to the beneficiaries, the people who have been injured from the wrongful death, to decide what process they want to take. It didn't invalidate. All it did was give the individuals the right to elect which method they wish to pursue.
So, what would this look like at the point of the decedent's admission into the nursing home? Would you anticipate that all of the potential beneficiaries would gather around and make a decision that should something happen to the decedent, they would waive the right to take the wrongful death matter to trial and would agree to arbitrate it? Is that what it looks like, practically speaking?
Practically speaking, if that's what if the nursing home wants to bind the beneficiaries, that's what they have to do, bring them in, sit down with them and say, this, your father has signed for himself. This is how he wishes to resolve any disputes that we have. It's a process, read through the process, here are the benefits, here's what you're giving up. If your father passes and you believe he passed as a result of our negligence, this process is available to you also. We'd like you to sign if you wish to do that. And then there can be a conversation with respect to it. Rather than the family being told afterwards that their father has died, the negligence is alleged, you can't go to court. Your father signed this document and we're not letting you get near a courtroom. Nor can you tell anybody with respect to what's taken place, because we have a confidentiality clause.
And your time is up.
Thank you very much.
The court will take the matter under advisement. A written opinion will be issued and sent to each side, and you can look on our website. So, thank you very much.